1968 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာ92 Civil Miscellaneous Application before ဦးစိန်သိန်း Judge မဆန်းရင် Applicant vs ဦးညို Respondent ဤစီရင်ထုံး Audio book ကိုထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးမိသားစုကစီစဉ်သည် Suit for divorce on the ground of matrimonial fault. Valuation for purpose of jurisdiction, plaintiff's right to choose the forum. Hell, ordinarily, it is the value put by the plaintiff on his suit that prima facie determines jurisdiction and in a suit of the nature brought by the respondent against the applicant where the subject matter does not admit of being satisfactorily valued, the plaintiff is at liberty to put any value he likes, provided the valuation is bona fide. Thus, if a plaintiff is found to have chosen a forum in accordance with the law, the burden lies on the applicant to make out a strong case for a transfer and that a mere balance of convenience in favor of proceeding in another court has been held to be not a sufficient ground. Madhu Prasad vs. Modi Chen, 1919, 41 ALL, page 381. Kam Raj vs. Daji, 1941, RLR, page 495, referred to. Utin for the applicant, Uja for the respondent, Usain Thin, judge. In Civil Regular Suit number 3 of 1967 of the Township Court, Danube, the respondent Unyo, a rice mill owner, filed a suit against his wife Masanyin, the applicant in this case for divorce on the ground of matrimonial fault. The suit was valued at K200 for the purpose of valuation. Subsequently, it was allowed to be withdrawn with liberty to file a fresh suit in respect of the same cause of action. Unyo then filed a fresh suit, being Civil Regular Suit number 2 of 1967 of the District Court, Maubin, placing a value of K20,000 for the purpose of jurisdiction, taking exception to the wide cleavage between the two valuations placed by the respondent in the two suits. The applicant Masanyin moved the district court to transfer the case to the township court on the ground that the suit pending in the former court was overvalued and that the overvaluation was malified. This contention did not find favor with the land trial judge, who rejected the applicant's application for transfer under Section 24 of the Civil Procedure Code. Hence, the present application before me. Two main grounds are advanced before me in support of the application for transfer. The first is that, in view of other litigations, both civil and criminal, pending between the parties to the suit in the courts at Danube, it will be for the convenience of the parties as well as the witness that the suit be tried at Danube. The second is that the plaintiff, having exercised his option of putting a notional value of the suits at K200, he is precluded from further exercising the option by valuing the suit at K20,000. Now, it must always be remembered that the plaintiff, as arbiter litis or dominus litis, has the right to choose his own forum or rather any forum the law allows him. Ordinarily, it is the value put by the plaintiff on his suit that prima facie determines jurisdiction and in a suit of the nature brought by the respondent against the applicant where the subject matter does not admit of being satisfactorily valued, the plaintiff is at liberty to put any value he likes, provided the valuation is bona fide. Thus, if a plaintiff is found to have chosen a forum in accordance with law, the burden lies on the applicant to make out a strong case for the transferent that a mere balance of convenience in favor of proceeding in another court has been held to be not a sufficient ground. Please see Madhu Prasad versus Motive Chen, 1941 ALL, page 381. It has also been held in the case of Kamraj versus Daji, 1941 RLR, page 495, that in a suit for restitution of conjugal rights, the plaintiff may, for the purpose of jurisdiction, put any value he likes in the relief sought and thus determine the court in which the suit is to be instituted, provided that the valuation is made bona fide and not in order to effect an improper purpose. Utin, the land counsel for the applicant, contends that in the present case, there are strong reasons to support that the valuation was the result of an improper motive on the part of the respondent to place difficulties in the way of the applicant in defending her case. His main reason for this inference is that the respondent had, in the previous suit before the township court, valued his suit several times lower than what he now puts in the suits before the district court. But a satisfactory explanation has been tendered in that the suit in the township court was filed without consulting a lawyer and, in view of the status of the parties as well as of the value of the property likely to be affected as an aftermath of the litigation. It has to be withdrawn on account of the formal defect regarding valuation. In the circumstance, I find it hard to hold that a strong case for the transfer has been made out which will justify invoking the provisions of Section 24 of the Civil Procedure Code. In the result, this application fails and is hereby rejected. In the peculiar circumstance of this case, there will be no order as to cause.